Good
All right,
morning.
looks like, good afternoon. Looks like we've got everyone here. Mr. Inocencio, this is your motion. I did read your submissions, gentlemen. Looks like our only hangup to a settlement, unfortunately, is a pretty large one. And it is whether or not Mr. Spiegel's client is entitled to any share of the profits of this business for the year 2020. I mean, everything else has essentially been resolved or is close.
If you look at my documents, Your Honor, and if Mr. Inocencio would approve them, I think that we could get past some of these issues. I think that, first of all, what Mr. Inocencio is trying to do is ask for specific performance of something that does not exist, that being a settlement. Secondly,
Well, wait a minute. It's not your turn to argue, Mr. Spiegel.
Oh, I'm sorry. I'm sorry.
Just trying to ask the question. Is the hang up right now is whether or not your client, Mr. Spiegel, is entitled to any share of the profits of this business for 2020.
That's one of eight problems.
Okay. I mean, if we could get past that problem, you might be able to get past all the others. But
Possibly,
as large as that problem is, that's a significant roadblock. So let me hear from Mr. Inocencio first, since this is his motion.
I'm sorry, Your Honor.
Thank you, Your Honor. I think we really have two issues. I think that is the largest issue relative to the claim for a share of the profits. But I also think that we have this issue relative to the non-competes. And I can address that also, but generally what I'd like to do is just address some procedural issues here. Number one, my motion was filed late yesterday because of the response I got from your clerk saying, yes, the judge will grant it. So we went ahead and filed the motion. I wasn't certain if the court was granting my request for an emergency motion, or we would have filed it earlier in the day. Number two, the requested relief in the motion related to getting the documents from Mr. Spiegel, and I have now from him his version of the documents that he would like this court to adopt as part of the settlement, that he'd like us to adopt as well. So I think we can at least start working on those. Relative to this issue of whether or not this agreement that we reached back on August 31st included a request or waived a request for profits, I think the court needs to look at one of the cases. It's actually the very first case that's cited by the defendants in their brief in support of their motion for declaratory order. Now, I recognize that this was sent last night. The court may not have had an opportunity to review all the cases that counsel cited in its brief, but I think it's important to note that the very first case, which is the McInnes versus McInnes decision, found at 260 Mich. App 280, 2004 case. And McInnes, by the way, Your Honor, is spelled M-A-C I-N-N-E-S. The defendants included that case because it stands for the proposition that a settlement agreement, such as a stipulation in property settlement in a divorce, is construed as a contract. We agree. We wholly agree with that premise. What's interesting to note about McInnes is that it actually is somewhat similar to the facts of this case. Even though it's not a divorce among spouses, it's equivalent to a business divorce. And in McInnes, the Court of Appeals considered whether a provision in the parties' consent judgment of divorce, which released all rights of either party to the proceeds of any life insurance policy on the life of the other, constituted a waiver of the defendant's right to life insurance proceeds after the death of his former spouse. The trial court held that that provision, which included for a release of all rights did act as a waiver. The Court of Appeals affirmed that decision. Specifically, the court noted that the provision at issue, which stated, quote, except as otherwise provided, all rights to the proceeds of any policy of life insurance shall hereupon become and be payable to the estate of the owner of said policy, end quote. The court then held, quote, the above provision is all-inclusive with regard to defendant's relinquishment of his right to life insurance proceeds from policies owned by his former wife, end quote. The court went on to say, this language is explicit in its intent to divest defendant of his interest in life insurance proceeds from policies owned by his former spouse. That specific provision in the case, Your Honor, is found at page 288. In our case, the parties' agreement provides that the defendants are relinquishing their rights to, quote unquote, all assets. There's no question that the parties reached an agreement on August 31st, 2021. There's no question, and the defendants, to their credit, have acknowledged that there was an agreement reached on August 31st. It's on page 1 of their brief. It also is clear that the defendants relinquished their right to all assets. Just as in McInnes, our agreement is all-inclusive with regard to the defendant's relinquishment of rights to all assets, and the language used in the agreement, quote unquote, all assets, is explicit in its intent to divest defendants of their interests. We have an agreement. Defendants have acknowledged the same. If the defendants believed for some reason that they should have been entitled to a share of profits at any point between August 31 and the time of closing, then you would think that that provision would be included because it's very specific. Here's what we have. We actually do have in this document a provision that addresses distributions. And if the court looks at it, this is attached as Defendant's Exhibit 1 to its brief. On page 1, this is my letter dated August 31, 2020. It says Doug Rogers and Rick Rogers will refrain from making any distributions to Airway's shareholders. That's the two of them. There are no distributions. The only time people would be entitled to distributions in this case from Airway would be if they were named Doug Rogers or Rick Rogers. And after closing, the only person that's entitled to distributions will be Doug Rogers, one of my clients, because he is retaining his interest in the business and Rick Rogers is relinquishing that. The only other time that distributions would be possible for Rick Rogers, one of the defendants, is before closing. And the agreement says that shouldn't happen. That's what the parties' agreement is. The parties' agreement is clear in the second full paragraph of our agreement, which is my letter dated August 31, 2020. It was faxed at 4:10 p.m. to opposing counsel. I have an email thread where that is specifically referenced, and I sent an email to Mr. Bernard on August 31, 2020 at 8:20 p.m. Copied on that is my partner, Christina Fisk, and also our mediator, Gary Soretsky. The email says, Paul, as a result of the letter I sent Joe late this afternoon, via facsimile at approximately 4:10 p.m., Joe and I have had a couple follow-up discussions this evening. Rather than send a confirmatory fax to Joe tonight, he and I agreed that I would send you an email and you would respond via email to confirm we have a deal after speaking with Joe tonight. This email shall confirm that we have an agreement based on my letter of earlier today at 4:10 p.m. and that Rick, Brett, and Ryan, effective immediately, will not return to Airway Welding for any reason. Their personal property will be boxed up promptly. Please confirm at your earliest convenience. Thank you. Then, 18 minutes later, I received an email response from Mr. Bernard. Bruce, I just spoke with Joe and relayed the substance of your email to him. He agrees that the parties have a deal based on your letter of 4:10 p.m. today. It goes on to say that they won't return to Airway and that the Airway will box up their personal property. We have an agreement based on the letter dated August 31, 2020, sent at 4:10 p.m. via facsimile. It's been confirmed, and that agreement says all assets. Now, Your Honor, I have been involved in transactions in the past where the parties have agreed that the purchase price shall be X, and it may be subject to a later adjustment based on inventory or something of the sort. We don't have an agreement like that. We have a firm fixed price agreement. I'm not going to state the amount on the record because the parties have agreed that the amount is confidential, and I know that the court is aware of that as well. Nevertheless, that agreement relative to that amount has never changed. In all of the hearings that we have been to this court for, I don't even know how many there have been since August 31, not one time, not once has opposing counsel suggested that they were going to try to change the amount of the transaction for the purchase price, or that they were seeking a distribution. That was never relayed. I've searched the transcripts that Mr. Spiegel has obtained and provided to me. I appreciate him doing that, but never was there a request made for additional distributions. Your Honor, this is a bait and switch. It's a request for additional compensation. And if the court looks specifically at page 2 of the defendant's brief, what the defendants are asking for in their motion is this. Defendants asked this court for a declaratory order stating that the parties' settlement agreement does not include a waiver of Rick's right to his share of Airway's profits for 2020, and that Rick retains this right in addition to his right to the other consideration. They know this is in addition to. They know it's consideration. That consideration was not set forth in the agreement. He did not say, well, I'm going to be making a claim for these profits. Instead, what he said was all assets. I will agree to accept this amount for all assets of Brit and all assets of Airway. All assets includes cash. It includes profits. It includes accounts receivable. Where would those profits come from? The cash and accounts receivable of the company. All assets means all assets. It doesn't mean all assets minus whatever I decide to add into it later. Your Honor, Rick Rogers was the treasurer of this company. He had access to all of the financial records before he left. And I understand that he hasn't been back since August 31 as a result of our agreement, but he was cognizant of everything that company was doing. He was familiar with its books and records. He's the treasurer. If he believed that there were profits out there to which he was still entitled, he should have said, well, my agreement includes all assets, but I still have this other claim out here. But that's not what he said. He said all assets. Your Honor, we would ask that the court, in reaching a determination relative to this issue, take into consideration the fact that we have an agreement, and that agreement is clear and it is unambiguous, and it constitutes a waiver of the defendant's claim to anything other than all assets. They've released everything for a firm fixed price. Thank you, Your Honor.
Thank you. Mr. Spiegel?
I'm going to divide this up into two parts. I'm going to take one part and I'm going to have Mr. Bernard address this waiver issue. But what we have here is a claim for specific performance for something that doesn't exist. For example, there is no agreement signed by the parties. And there's a stipulation in court order that the parties agree to appoint a receiver if there's no settlement. That's Exhibit 19. Airway is not even a party to this action anymore. This is being brought on behalf of Doug to enforce a contract between Airway and Rick. But the agreement of August 31st is an agreement between Doug and Rick, where Doug is trying to buy the assets of Brit But because Rick doesn't own the assets of Brit or Airway, it is an impossibility. It could have been structured possibly differently. So there's no signed documents by my clients. There's no contract. There's no settlement agreement. There's no cause of action. Bruce has rejected each and every one of my problems and solutions. And if you look at exhibits 2 and 3, this goes back to September, where we were trying to determine what the distributions would be. In addition, Bruce's documents is an asset purchase, not a stock purchase. It's totally inappropriate. It contains liability for environment, for employees, all sorts of things that make absolutely no sense. And Rick's documents are what I would call fatally flawed. He keeps conflating, or he keeps saying the purchase price and distributions. Those are two entirely different things. I have been concerned about phantom income. And if you read the declaration of Mr. Friedman, he comes to the conclusion that there's an amount of money due both parties for distributions. And the August 31st is silent as to those distributions. It doesn't say Rick is waiving. He's only saying that he won't get it until December 18th. It doesn't say he's waiving it. There's no words of waiver in this. This is not a judgment. This is not an agreement. This is not put on the record. So what are the fundamental disconnects? Mr. Incencio has drafted an asset purchase where Rick cannot sell the assets of Airway. When you sell a share of General Motors stock, you're selling the stock. It's the end of your liability. When you own a share of General Motors stock, what you have is a percentage of the company. There is, when you what Mr. Incencio's documents are talking about is, for example, warranties and representations that Rick can't make. The transfer of intellectual property rights he doesn't own. Environmental issues he's responsible for that he can't be responsible for. Additionally, there's absolutely nothing in this agreement as to what happens to the profit sharing contributions. And Rick is a trustee. Airway is the plan administrator. None of the corporate formalities have been addressed by Bruce, even though I have sent him numerous letters. And I even spent hours and hours drafting a proper set of agreements. There are going to be at least 30 to 40 exhibits to this very multi-million-dollar deal. There was no real estate purchase agreements.
Please, as a reminder, the amount is confidential. Just as a gentle reminder.
I understand.
Okay.
I just said,
I heard you. Just as a reminder.
Bruce did not provide a mutual release and stipulation to dismiss the case. There's been no transparency for the loan. First of all, we specifically set out in my November 27th letter that there needs to be transparency for the loan. You need to have corporate approval of a loan. We don't know what the liabilities are for this loan. We don't know what was said about Airway or Brit. In addition, Your Honor, there's been nothing addressed to the buy-sell agreement that Airway has. There's been nothing addressed with respect to the buy-sell provisions in the operating agreement of Brit.
So Mr. Spiegel, let me stop you. So if all of these things you are saying you want me to accept as being valid, why was the response to Mr. Innocencio's letter, we accept, we have a deal?
Because it was a deal which is merely a term sheet. It is not a contract. It is merely a term sheet. It has no specifics. It wasn't signed by my client. It has nothing
Then
to
why
do with the
wasn't your
pension.
response, we can't accept this because you failed to address A, B, C, D, E, F, G, that you've just gone into great detail telling me about? Why was the response is, we got a deal?
I was hoping we could work out these problems as a normal transactional deal.
All right, well,
And so
let me stop you.
because
There
my
is a
client
deal.
is not going to sign
Let
any
me
of these
stop
documents.
you. Let me
I'm sorry.
stop you. There
can't hear
is
you.
a deal. The agreement and the response to it constitute an agreement for the sale of all of your clients' interest in and to these companies or any of their assets. And I will specifically enforce that deal. I'm going to give Mr. Bernard a chance to address the issue about whether or not the deal includes the distributions before I rule on that. Mr. Bernard, go ahead. You're muted.
Mute.
Sorry about that. Thank you, Your Honor. I'd agree
You're
with
welcome.
Mr. Innocencio that the McInnes case is important and applicable here, but I think its application is very different than the ones he suggests. And understanding that begins with recognizing that at the time, on August 31st, at the time of the determination of the settlement terms, Rick had rights as a shareholder, which included his rights to distributions, and he had a right as a shareholder to the ownership of the shares. Now, when he conveys the ownership of the shares at the closing, that doesn't mean he surrenders the rights that he had before the closing occurred. He surrenders all of the rights in the shares at the time of the closing, but before the closing, or you could possibly say before August 31st, Rick retains all of his rights to distributions. The key thing about McInnes is that it says, one of the parties conveys all of his rights, that is, all of his rights to the insurance proceeds. This agreement doesn't say that. It says, I'm going to convey you my ownership interest at the closing, and I'm not going to come to work anymore. And there's other considerations, but it doesn't say I waive my right to a share of the profits that have the right that has accrued up until this point. And I think that's the crucial distinction, Your Honor.
Can I
Thank you. I'm not impressed with the distinction. The accrued profits of the corporation are indeed included in this agreement. The defendant has no claim to those in addition to the consideration that was offered. The agreement clearly says there will be no distributions until closing, and it doesn't say, in addition to this substantial consideration, whatever it is, he's entitled to retain a share in the very specific asset that creates the profit of this company. By reason of the failure to address it, it's included. It would have had to have been a carve out. I think the parties had a meeting of the minds. I think there is a binding enforceable agreement, and I am going to grant specific performance of that agreement.
By who, Your Honor? Can I ask by who?
If there's disagreement as to the precise language of a warranty deed, or the precise, or if it is a warranty deed, if there's disagreement as to the precise language of a covenant not to compete, I would say each of you submit your proposal on that, and I will order the one that I find most reasonable under the circumstances. This deal is done. Gentlemen, get it done.
Your Honor, my clients will not sign the documents. My clients will not agree to sign any of the documents. We will have to take an appeal. There is no contract. Airway is not a party to this case.
Mr. Spiegel,
I'm
Mr.
sorry.
Spiegel,
It's just
I've
not going to
ruled.
happen.
I
don't-
ruled.
If you want to enter an order, that's fine. We will appeal it. We are
I'm
not
en-
going to
I'm
close.
entering an order granting specific performance of the settlement agreement.
Your Honor, I have one
There
question.
is no settlement agreement, according to my client, Your Honor. And
Well, according to
what
your
you-
judge, there is, Mr. Spiegel, and that's
Well-
the important opinion that matters.
well, my clients are not going to sign any documents.
You may submit an order granting specific performance of the parties' settlement agreement.
Thank you, Your Honor. I will do that.
Thank you.
Have a good day, everybody.